Hello, welcome all. Today I'm going to give exam topics regarding evidence law. The topics here I'm mentioning there are around 11 topics where 90% of the exam previous exam questions are covered. Coming to theory of relevancy, the essential incidents of the theory of relevancy can be highlighted, which are that evidence must be given in a suit or proceeding that must relate to either a fact in issue or the relevant fact. Coming to suit or proceeding, under section 5, evidence is given in suit or proceeding. Suit means a civil suit in civil court. A proceeding may, however, be a civil or criminal proceeding. The fact in issue. It means the matter in controversy. Section 3 defines fact. The fact means and includes anything, state of things or relation of things capable of being perceived by the senses, any mental condition of which any person is conscious. Illustrations. A man heard or saw something is a fact. A man has a certain reputation is a fact. The man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense. Indian Evidence Act adopts a well-known philosophical division of facts into Clause 1 deals with physical and Clause 2 deals with psychological. Direct evidence is always possible of physical facts, but as regards the psychological facts, the only direct evidence possible is that of a person who is conscious of his mental condition. Very often, it is the guilty mental condition that needs to be established, and this can only be done with circumstantial evidence and proved relevant facts. Illustration. A is charged with the murder of B. Before A can be convicted, the prosecution will have to establish that B died, that it was the case of homicide and not suicide, that A caused B's death, and that A intended to cause B's death. All these facts are in issue. Proof of facts in issue. The facts in issue can be proved by direct evidence and circumstantial evidence when no clear and direct evidence is available. Direct evidence. The Supreme Court has also observed that in very few cases, direct evidence of the facts in issue is available. The principal fact or factum probandi has inevitable to be proved indirectly by inferences from factum probans, which means evidentiary facts. Circumstantial evidence. It is sometimes referred to as presumptive evidence. Illustrations. A is charged with the murder of B. At the trial, a witness C gives evidence that he saw A stabbing B. This is the direct evidence. C can make a statement that how that he saw A running from the place where B's corpse was found with the blood-stained knife in his hand. This is circumstantial evidence, a relevant fact which if delivered, many may convince the court of guilt of A. The state of Uttar Pradesh versus Ravindra Prakash Mittal. In this, the husband was the only person who had access to the room in which the wife died. The medical report was that she was first strangulated and then burnt. The Supreme Court summarized the result of the case in terms of the following points. The circumstances for which the conclusion is drawn must be fully established. They should be conclusive in nature. The established fact should be consistent with the hypothesis of the guilt and inconsistent with the innocence. The circumstances should to the extent of moral certainty, exclude the possibility of guilt of any other person other than the accused person. Coming to relevant facts. Section 3 defines a relevant fact as one fact is said to be relevant to another when the one is connected with the other any of the ways referred to in the provisions of this act relating to the relevancy of facts. Section 8 says any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. If a fact is logically relevant and there is no reason for excluding it, it must be also legally relevant. And the fact that it is legally relevant under more than one section or rule does not matter. In Latin, it is also called factum probans. Ram Ratan versus State of Rajasthan. The accused was convicted on charge of a murder. The evidence against him consisted of evidence of single witness and the statement by another witness that the former witness told the latter immediately after the incident that the appellant committed the murder. Supreme Court held that there are only two things which are essential for Section 127 of Indian Evidence Act to apply. The witness should have given testimony with respect to some fact. He should have made a statement earlier with respect to same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact. Coming to second topic, dying declarations. It refers to a declaration made by a person by way of signs, verbal communications, conduct or writing soon before his death or while he is on deathbed. Section 32 1 of Evidence Act talks about the relevancy of dying declaration. It says that a statement, whether written or verbal, made by a person who is died, who cannot be found, or whose attendance can't be procured in the court without unreasonable delay, is relevant when it relates to cause of death. Dying declaration under Indian Evidence Act is admissible in all proceedings, civil or criminal, where the question of death of a person making it is an issue, whereas under the civil proceedings it is admissible only in homicidal cases. The reason for admitting dying declaration are that it is best possible evidence available, the occasion is solemn, and the dying man is face to face with his maker without any motive for telling a lie. Such statements are known as dying declarations, and if the dying man makes it an on oath to a magistrate, it is called dying deposition. Conditions of dying declaration. It must be a statement, written or verbal. The statement must relate to the cause of death or circumstances of the transactions which resulted in his death and not the cause of death of someone else. The cause of the person's death must be in question. There must be proximity of time in making the of statement and time of death, and the declaration must be mentally fit. The declarant must be mentally fit. Dying declaration can be made to any person, a doctor, magistrate, police personnel, friend, or any other person. However, if it is recorded by a magistrate, that accords more reliability and authenticity. The statement must be complete and not vague. The declarant must be competent as a witness, that is, he must be capable of being a witness if he weren't dead. It is not necessary that the declarant is under the expectation of death while giving the statement. As of general rule, hearsay evidence is inadmissible under the Evidence Act. Dying declaration is an exception to hearsay rule, where a statement is complete and reliable to the satisfaction of the courts. The courts can convict a person on the basis of dying declaration. Case laws. Queen Empress versus Abdullah. The accused murdered a prostitute by cutting her throat with a razor. When she was taken to police, she couldn't speak and was making signs and gestures. Under Section 8, a dying declaration can be made verbally or in writing and by any method of communication like signs, words, or others otherwise provided the indication is positive and definite. Dowry deaths. Vidya Devi versus State of Haryana. Death by burning took place within 7 years of marriage. The facts proved the existence of a proximate and live link between the effect of cruelty caused by dowry death and dowry demand and death. Conviction is followed. Dying declaration when declarant survives. When he survives, his statement is admissible under Section 157 as a former statement made by him in order to corroborate or contradict his testimony in court respectively. FIR and complaint as dying declaration. An injured informant who gives information to the police as to commission of an offence and dies thereafter, such informational statement can be treated as dying declaration if it relates to the cause of informant's death. Gujjala Surya Prakash Rao versus Andhra Pradesh. The dying declaration recorded by magistrate if he survives the statement so recorded considered under section 164 CRPC. Coming to third topic, confessions. The definition is not contained in Indian Evidence Act 1872. Stephen, in his book Digest of the Law of Evidence, defines a confession as an admission made at any time by a person charged with the crime, stating or suggesting the inference that he committed the crime. The confession is a statement by an accused suggesting the inference that he committed the crime. Confessions are dealt under section 24 to 30. 24 to 26 sections deals with confessions which are irrelevant, and 27 to 30 deals with confessions which the court will take into account. Confessions and admissions. All admissions are not confessions. Confession, it is received in evidence as same person as admission. Admissions can be either civil or criminal proceedings. Confessions are seen only in criminal proceedings. Admissions need not be voluntary to be relevant. Confessions to be relevant must be voluntary. Relevant admissions can be made by agent or stranger. The confession should be made only by the accused himself. The confession must be true and voluntary. There are two types of confessions: plenary, which is complete; non-plenary, which is incomplete. This is inapplicable in this classification is inapplicable in India. Another method is judicial confessions and extrajudicial confessions. These are confessions made before court or recorded by magistrate under section 164 CRPC. The magistrate who is about to record confession must warn the accused that he may or may not be taken as an approver. Extrajudicial confessions. These are those made either to the police or to any other person other than judges and magistrates as such. The extrajudicial confession so made must be voluntary and also made to an independent person. The value of confessions depends upon the veracity of the person to whom confession was made and who appeared to testify to it. The reliability of extrajudicial confession is best explained by Supreme Court in State of Karnataka versus P. Ravikumar. Reliability of judicial confession. State of Tamil Nadu versus Kuti. Magistrate has observed all legal formalities in recording confession held proper. The content of judicial confession is not so important in the sense whether the accused attributed any role to himself. Confessions to person in authority discussed in section 24. This section deals with confessions which are not voluntary. To exclude confessions, it is not necessary to prove that it was the result of inducement, threat, or promise. It is sufficient if a legitimate doubt is created in the mind of the court if it appears to the court that the confession was not voluntary. Confession would be irrelevant if the following conditions were satisfied. It should appear to the court to have been caused by any inducement, threat, or promise. That inducement, threat, and or promise must have reference to the charge against the accused person. It shall proceed from person in authority. The court shall be of the opinion that the said inducement, threat, or promise is sufficient to give the accused person a reasonable advantage or avoid proceedings against him. Confessions to police officer. Section 25 enacted confession to police officer need not be proved. In case in Ilyas versus Collector of Customs, the lays down the test for determining when the officer is deemed to be police officer under Section 25 of Indian Evidence Act. Confessions to a police officer under Section 25 is only a source of information for putting the criminal in motion. It cannot be the basis for the lower court to cause any conviction. Accused can make shelter under Section 25. Section 26, it prohibits proof against any person of a confession made by him in the custody of police officer unless it is made in the immediate presence of a magistrate. Section 21 provides that when any fact or information received from a person accused of any offense in the custody of the police officer, whether it amounts to confession or not, as related to the fact, may be proved. State of Bombay versus Kattikalu Ogad. The accused was convicted for offense of murder. One of the items of evidence against him was a statement under Section 27 Indian Evidence Act which led to discovery of firearms used in committing crime. Extrajudicial confessions. Section 29 deals with extrajudicial confessions which are not governed by Section 24 to 28. That Section 29 confessions otherwise relevant not to become irrelevant because of promise of secrecy, consequence of deception. When he is drunk, he made answers to questions which he did not have answered. Confessions of co-accused, Section 30. Consideration of proved confession affecting the person making it and others jointly under trial for same offence. Kashmira Singh versus State of MP. Four persons were charged with murder and at the trial one of them confessed implicating the appellant, allowing the appeal on the charge of murder. The Supreme Court observed that where the evidence against the co-accused sufficient, if believed, to support his conviction, then the confession said in Section 30 may be thrown as additional reason for believing that evidence. Coming to fourth topic, admissions. According to Section 17 of the Indian Evidence Act 1872, admission is defined as any statement made by any of the persons which suggest any interference, inference as to any fact in issue or relevant fact and certain circumstances. Admissibility simply means the power to approach. The admission can be oral or documentary or contained in electronic form. Thus, the admissibility of evidence means any evidence or document used in the court of law to prove and disprove or disprove alleged matters of fact. Conditions of admissibility of evidence in court. Section 120 of Indian Evidence Act, Section 20 of Indian Evidence Act 1872 states about the admissions of persons referred to or by a party to a particular suit. This section brings another exception to the general principles of admissions made by strangers to the suit. Admissions made by a third party are considered irrelevant and are admissible when a party refers another to him for information in regard to uncertain or a disputed matter. There are two basic factors that are considered when determining whether evidence is admissible or not: relevant and reliable. Relevant: the evidence must prove or disprove an important fact in the criminal case. If the evidence doesn't relate to the particular fact, it is considered irrelevant and is therefore inadmissible and is also not permissible in court. Reliable: the reliability refers to the credibility of the source that is being used as evidence. This usually applies to witnesses' testimonies. The Supreme Court in Ram Bihari Yadav versus State of Bihar observed that the term relevancy and admissibility are not interchangeable, though sometimes they may be taken as synonymous. However, all relevant evidence may not be admissible, but all admissible evidence is relevant. It is determined by the ruler of the Act that the relevancy is the test of admissibility. Coming to next topic, opinion of experts. Section 45 Indian Evidence Act deals with opinion of experts. It says when the court has to form an opinion upon a point of foreign law or of source of act as to identify of handwriting, the opinions upon that point of persons specially skilled in such subject are relevant facts. Such persons are called experts. The question is whether the death of A was caused by poison. The opinion of experts as to the symptoms produced by the poison by which A is supposed to have death. The question is whether a certain document was written by A. Another document is produced which is proved or admitted to have been written by A. The opinion of experts on the question whether the two documents were written by the same person or by different person are relevant. Case laws. Hanumant versus State of MP. A constitution bench of Supreme Court has held that the word expert in Section 45 Indian Evidence Act includes expert in type of typewriters as well. Typewriting also falls within the meaning of the work handwriting. Patturanjan versus State of Tamil Nadu. The identification of dead body was made on the basis of superimposition test and the evidence thereof was relied on by the trial court and the High Court. Mahindran versus State of Tamil Nadu. In the instant case, there was inconsistent versions of the expert witness and the eyewitnesses about the time of injuries sustained by the victim. The eyewitnesses account, if truthful and credible, shall prevail over the expert opinion. The medical examination of potency. A divorce petition was filed by the wife on the ground of husband's impotency. The court allowed medical examination of the husband for ascertaining the truth. A direction of this kind could be made by using the court's inherent power as conferred by Criminal Procedure Code. There was no infringement of human rights in this respect. Opinion of examiner of electronic evidence. It is only when an electronic record is duly produced in terms of sections 65B Indian Evidence Act that the question arises as to its genuineness. At this stage, the court can resort to the provisions of 45A to take opinion of examination of electronic evidence. Coming to sixth topic, facts of which evidence need not be given. It is not necessary to give evidence of those facts which are court knows them, the opposite side has admitted them. Section 56 to 58 deal with these facts. Section 56, facts judicially noticeable need not be proved. Section 57 says facts of which court should take notice. Section 58 says facts admitted need not be proved. Section 56 discusses judicial notice. The facts judicially noticeable need not be proved. The facts of which the court will take judicial notice need not be proved. Judicial notice means that the court or judge will take notice of existence of certain facts without requiring any evidence to be given for those facts. The reason is that they are considered to be well known that it would be an insult in our knowledge and intelligence if evidence is offered to prove the existence of those facts. The facts in which judicial notice is taken. Under section 57, the court shall take judicial notice of the following facts. That means they are existent, the fact which is existent will be known to the justice or court. They are like all laws in force in the territory of India, articles of war for Indian Army, Navy and Air Force, the seals of all courts of India established by government authority. In public administration, the seals of courts of admiralty, maritime jurisdiction, and of notaries public. All seals which any person is authorized to use by act or regulation having the force of law in India. The accession to the office, names, titles, functions, and signatures of persons filling for the time being any public office, if any. Matters of common knowledge, they are the existence, title and national flag of every state or sovereign recognized by Government of India. The divisions of time, geographical divisions of the world, any public festival, fests and holidays notified in the official gazette, the territories under dominion of Government of India, the commencement and continuation and termination of hostilities between the Government of India and any other state or body of persons, the name of members of officers of the court and their subordinate officers and assistants, and also of all officers acting in execution of its process, and all advocates, attorneys, proctors, wakils, pleaders, or other persons authorized by law to appear or to act before it, the rule of the road, land, or sea. In all these cases, and also on all matters of public history, literature, science, or art, the court may resort for its aid to appropriate books or documents for reference. Case laws in Ujagar Singh versus Jio, a Punjab custom that a sister is excluded from inheritance of her brother property by collaterals was sought to be established by reference to Rattigan's Digest. The Supreme Court held that since no judicial notice of such custom could be taken, it had to be proved under Section 48 Indian Evidence Act, and in the absence of such proof, it could not be held to have been proved. Coming to formal admissions, Section 58 deals with formal admissions. They are called because They are made deliberately in contemplation of a judicial proceeding or during the judicial proceeding. Such facts, having been admitted by one party, need not be proved by the other. So, judicial admissions made during judicial proceedings bind the maker absolutely. Such judicial admissions constitute waiver of proof. In case laws, L.K. Verma versus HML Limited, where the delinquent employee admitted that he abused the officer in the filthy language. The court said that no further evidence was necessary, though some witnesses were also examined, but the fact was self-proven on the face of it. Rangappa re, it is instructive on the issue where it was ruled that the admission or consent by the lawyer of the accused to dispose with medical witness shall not relieve the prosecution to prove the nature of injuries and that the injuries were such as would cause death in the ordinary course of time. Criminal and civil admissions. The admissions under Section 21 Indian Evidence Act, civil admissions is one made by the party against whom it is tendered before the proceedings in which it is sought to be tendered in evidence. Even if the accused was answered to questions made by the court under Section 313 of CRPC, it cannot be utilized to fill the gap in the prosecution theory. Facts of which evidence cannot be given. There are some facts of which evidence cannot be given though they are relevant. Facts coming under section 122, 123, 126 and 127 for which evidence prohibited. These sections come under witnesses. The principle of estoppel covers some facts of which evidence prohibited. The principle of estoppel. The principle provides that a man cannot approve or disapprove or that a man cannot blow hot or cold or again that a man shall not say one thing at a time and later on say a different thing. This principle is laid down in section 115. The illustration is A intentionally and falsely leads B to believe that certain land belongs to A and thereby induces B to buy and pay for it. The land afterwards becomes the property of A and A seeks to set aside the sale, saying that he is not entitled to land at that time of sale. He must not be allowed to prove his want of title. This explains the doctrine of promissory estoppel, where the promise, assurance, or representation should be binding on the party making it, and that party should not be permitted to go back upon it if it would be inadequate to allow him to do so, having regard to the dealings which have taken place or are intended to take place between the parties. Applicability. The doctrine may be applied against government where the interest of justice, morality, and common fairness dictate such a course. It is applicable against state even in its governmental, public, or sovereign capacity where it is necessary to prevent fraud or manifest injustice. In case of Pratima Chaudhary versus Kalpana Mukherjee, the Supreme Court explained the law and philosophy of the rule of estoppel, holding that it needs to be understood that the rule of estoppel is a doctrine based on fairness. The above provisions reveal four salient preconditions. Before invoking the rule of estoppel, one party should make a factual representation to the other party. The other party should accept and rely upon the aforesaid factual representation. Having relied on the aforesaid factual representation, the second party should alter his position. The instant altering of position should be such that it would be morally wrong to require him to revert back to the original position. Estoppel, the principle of estoppel is classified under three heads: estoppel by record, estoppel by deed, and estoppel in pais de horse. The instrument are usually estoppel in pairs. Estoppel by record arises in cases where a judgment has been given by a competent court and the effect of it is that the matters decided cannot be reopened by a person who is a party to the judgment or his representative. This rule is not followed in India, but rely upon res judicata to get the same effect. Estoppel by deed also does not obtain in India. In English law, if a person makes a statement or in a deed, he cannot say the opposite of it later. In India, however, the position is that a statement in a deed is only admission under Section 31 and it does not operate as conclusive proof. Equitable estoppel. In case of PC Chaco versus LIC, where the decree holder's income tax return showed that he had received substantial payment under the decree and only some amount remained, he was not allowed to deny the fact of such payment. Estoppel in pairs refers to an estoppel which does not spring from a record or a deed. It is made to appear to the jury by competent evidence. By an estoppel in pairs, a party is prevented by his or her own conduct from obtaining the enforcement of a right which would operate to the detriment of another who justifiably relied on such conduct. Estoppel by conduct. A plea for estoppel cannot be availed of if there was no duty owed by a person sought to be estopped. Before anyone can be estopped by a representation inferred from a negligent conduct, there must be a duty to use due care towards the party misled or towards the general public of which the party misled is one. Estoppel or admission. In case of an admission, there is a statement, and in case of an estoppel also, there can be a statement as shown by the word declaration in section 115. Estoppel and conclusive proof. Conclusive proof is defined as when a fact is declared by the act as conclusive proof of another, the court shall regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. In conclusive proof, the court believes one fact upon another, whereas in a case of estoppel, the very same fact contained in the statement cannot be denied. Other kinds of estoppel are estoppel and fraud, estoppel and presumptions, estoppel and res judicata, estoppel and waiver, and estoppel against a tenant and license. This is just for a completion sake. Sections in witnesses where evidence cannot be given. Section 122 Communications during the marriage. Section 123 relates to affairs of state. Section 126 deals with professional communications. Section 127 Sections 127 shall apply to interpreters. Coming to eighth topic, burden of proof. It is also called onus probandi. The burden of proof is best explained with illustration. A files a suit against B on a promissory note. B admits the execution of the promissory note but denies having received any money from A. If A to succeed, A will have to show that money is lent to B and B has executed the promissory note promising to pay the money to A. The burden of proof here is mentioned to on A. Now B has to introduce the evidence because he has admitted the execution of the promissory note. The third is because B did not assert repayment. Therefore, if no evidence at all is introduced by either side, A succeeds. The rules of burden of proof are set out in sections 101 to 103. Section 101 says when a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Section 102 says on whom the burden of proof lies. The burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. From the presumption drawn from Section 118 Negotiable Instruments Act 1881, it would not be possible to say who would fail, that is A or B in the previous illustration. Section 103 says burden of proof as to particular fact lies on that person who wishes the court to believe in its existence unless it is proved by any law that the proof of that fact shall lie on any particular person. Illustration. A desires a court to give judgment that B shall be punished for crime which A says B has committed. The burden of establishing the case is on A under section 101 and the burden of introducing evidence is also on A because under section 102 if no evidence is adduced B will be acquitted. The presumption of law being that a person is innocent till he is proved to be guilty, and applying section 103, nowhere any rule of law imposing the burden on B to prove his innocence can be found. Specific rules of burden of proof. Section 104 to 103 specifically throw the burden of proof proving certain facts on a particular person. Section 104 deals with the burden of proving a fact to be proved to make evidence admissible. The rule is that the burden of proving any fact necessary to be proved in order to enable any person to give evidence of any other fact is on the person who wishes to give such evidence. A wishes to prove a dying declaration made by B. B's statement will not be admissible as a relevant fact unless it is first shown that B is dead. It is only when it is found that B is dead that the fact enables A to give evidence of the dying declaration. So the burden of proving that B is dead lies upon A. In case laws, Daulataram versus Sodha, a person who alleges that the will in question was obtained by coercion or undue influence, the burden of proving this fact lies on him. Jalandhar Improvement Trust versus Sampuran Singh. If a person claims to be entitled to preferential treatment in the allotment of plots under certain rules, the burden of proof is on that person under section 103. Ajit Kaur versus Dalbir Kaur. The nephew who had to prove that the sale deed was obtained without exercising undue influence could not do it. The sale deed was in fact a fraudulent document made from the papers which contained blank signatures and could not prove the allegations. The deed was accordingly held to be valid. Coming to ninth topic, standard of proof. Standard of proof determines whether the evidence a party has produced in support of its factual allegations is sufficient to establish the facts in question. The standard may be determined by the relevant substantive law or customary practice. Standard of proof must be considered both in terms of the obligation on the party with the burden of proof and in terms of the tribunal's conclusion after each party has presented its evidence. Example, a claimant with the burden of proof may present a prima facie case that satisfies the standard of proof required at that stage, but the respondent may subsequently present evidence that leads to the tribunal's decision in the respondent's favor. The weighing of evidence is thus a relative exercise considering the relevance, materiality, and honesty of the conflicting evidence before the tribunal reaches its decision. Factors affecting the standard of proof. Tribunals may consider a substantive nature of an allegation brought against a party when determining the applicable standard of proof. For allegations of particular gravity, tribunals may apply a higher standard of proof, such as in sports arbitrations, convened to consider questions about the use of performance enhancing drugs. The preferred method is for tribunals to apply uniform standard of proof and not attempt to set up multiple standards depending on the circumstances of the case. Thus, although approaches to standard of proof may vary, the legal articulations of the standard of proof should remain constant. The standard of proof is proof beyond reasonable doubt. There has been some inconsistency in assessing the standard of proof required of the accused and the prosecution in cases of dowry death where the presumptive value clause of section 113b is to be invoked. Sher Singh versus State of Haryana. The decision bench of Supreme Court in this case, while dealing with section 304b IPC, the section 113b Indian Evidence Act, held that the prosecution can discharge the initial burden to prove the ingredients of section 304b even by the preponderance of probabilities. Ramakant Mishra versus State of UP. The Supreme Court observed that the accused persons charged with dowry death failed to enter the witness box in order to prove their innocence, which they ought to have done once the prosecution was able to show the presence of conditions required for raising the presumptions under section 113b. Coming to witnesses. The placing evidence before court after ascertaining the relevant facts which are to be proved is by two methods, witness witness and documents. Even in documents, their genuineness will have to be proved through witnesses. The topic witnesses is discussed under the following questions. Who are competent witnesses? How many witnesses are required to prove a fact? Can every witness be compelled to answer every question? How are the witnesses to unfold their knowledge to the court? How is their credibility tested? What is the procedure when a witness lets down the party? Who calls him as witness? Can a witness can refresh his memory by referring to notes? Judges' power in relation to witnesses. Who are competent witnesses? Section 18 gives about competent witnesses. All the persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions by tender years, extreme old age, disease, whether of body or mind or any other cause of same kind. In case of R.D. Naik versus State of Gujarat, it was held that a child of tender age can be allowed to testify if he has intellectual capacity to understand questions and give rational answers thereto. The decision on the question whether the child witness has sufficient intelligence primarily rests with the trial judge. Section 119 provides that a person unable to verbally communicate his or her statement is also competent to testify. Section 120 says in all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be competent witnesses. In criminal proceedings against any person, the husband or wife of such person respectively shall be competent witnesses. How many witnesses are required to prove a fact? Section 134 says about number of witnesses. No particular number of witnesses shall in any case be required for the proof of any fact. In case Sudeep Kumar vs. State of West Bengal, the plurality of witness in a criminal trial is not a legislative intent. If the testimony of one sole witness is reliable on the touchstone of credibility, the accused can be convicted on the basis of such sole testimony. Can every witness be compelled to answer every question? The law on this point is stated under sections 121 to 132 Indian Evidence Act. In some cases, we find the witness has a privilege, that is, he need not answer the question if he does not want to. In other case, in case of prohibition, there is that is even if the witness is willing to answer, the law prohibits. Illustrations: A on his trial before the Court of Session says that a deposition was improperly taken by B, the magistrate. B cannot be compelled to answer questions as to this except on the special order of the Supreme Court. Vishal Kaushik versus Family Court. The tape recorded conversation between the spouses has been held to be admissible in evidence, but not so if recorded without the knowledge of spouse. Admission without such knowledge would be violative of right of privacy under Article 21 of the Constitution. How are witnesses to unfold their knowledge to the court? Section 135 Order of Production and Examination of Witnesses. The rules set forth in Section 137, 138 and 141 to 143. 137 says Examination in Chief. The admission of witness by party who calls him shall be called his examination in chief. The cross-examination. The examination of witness by opposite party shall be called his cross-examination. Re-examination. The examination of a witness subsequent to the cross-examination by the party who calls him shall be called his re-examination. Section 138 says Order of examination. Witness will be examined in chief, then cross-examined and if needed, re-examined. The examination and cross-examination must relate to the relevant facts, but the cross-examination need not be confined to the facts to which the witness testified on his examination in chief. Anil Sharma vs. State of Jharkhand, a prayer for an order of re-examination has to be considered objectively. A prayer of this kind by the accused was twice rejected by the trial court. It was also dealt with elaborately by the higher court. Supreme Court refused to interfere because it had obtained finality. Leading questions. Section 141 defines leading question. Any question suggesting the answer which the person is putting it wishes or expects to receive is called a leading question. Section 142 says when they must not be asked, when the leading questions must not be asked. They must not, if objected by the opposite adverse party, be asked in examination in chief or in re-examination except with the permission of the court. Section 143 says when they must be asked, they may be asked in cross-examination. The cross-examination means a minute examination of a story with a view to check it or to elicit any suppressed facts. How is the witness credibility tested? If the witness denies suggestions, evidence to contradict him can be called. Such a situation provided for in section 153 and 155. Section 153 says exclusion of evidence to contradict answers to questions testing the veracity. The questions asked to shake the credit of witness by injuring his character, no evidence shall be given to contradict him. But if he answers falsely, he may afterwards be charged with giving false evidence. What is the procedure when a witness lets down the party who calls him as witness? Section 154. It may be possible that a witness called by a party to a proceeding does not support its case. Such a witness is called hostile witness. Krishan Chandar versus State of Delhi. The previous statement made by a witness under section 161 and 162 CRPC was contradicted by him in his testimony before the court. The court said that if his previous statement is to be relied on, strict proof of such statement would be necessary in terms of section 145. When can a witness be declared as hostile? For getting a witness declared hostile, it is necessary that he should have appeared and made a statement detrimental to the interest of the party who called him. It will not be enough for this purpose to show that he appeared in some earlier cases filed by the petitioner's sister for similar relief, like in case of Rehana Begum versus Mirza M.S. Beg. Section 152 Class 2 provides that the party whose witness was declared hostile at his application is nevertheless entitled to use the whole or any part of the testimony for his purpose. It is not necessary that the testimony of hostile witness should be rejected in its entirety. Can a witness refresh his memory by referring to notes? This is given under in section 159 to 161. A witness may, while under examination, refresh his memory by referring to any writing made by himself at the time of transaction concerning which he questioned or so soon afterwards that the court considers it likely that the transaction was at that time fresh in his memory. Munshi Prasad was versus State of Bihar. It was observed that a postmortem report is prepared by a doctor, and this document by itself is not a substantive evidence, but it is the doctor's statement in court which has the credibility of a substantive evidence and not the report. Judge's power in relation to witnesses. Section 155 says judge's power to put questions or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form, at any time of any witness or of the parties about any fact relevant or irrelevant. Bablu Kumar versus State of Bihar, it has been observed that the duty of presiding judge is to play a proactive role to ensure a fair trial. The court cannot be silent spectator or mute observer when it presides over the trial. The presiding judge can invoke his powers under Section 165 Indian Evidence Act and put questions to the witness to elicit the truth. Presumptions in case of dowry deaths. Coming to introduction, dowry death was first used around 1977 to 78 when investigations pointed out that death of many women which were earlier labeled as suicide and accidental deaths were actually due to extortion by her in-laws in dowry from the bride. Section 113B Indian Evidence Act 1872 and Section 304B Indian Penal Code was added by the Dowry Prohibition Amendment Act 1986 in order to provide speedy justice in case of dowry deaths and protect women from such torture going on. Definitions. Dowry death is defined in Section 304B Indian Penal Code as the death of any woman within 7 years of her marriage due to burn or any other bodily injury and had occurred under abnormal conditions. It is also important to show that the woman was subjected to cruelty and harassment before her death by her husband or in-laws in relation to demand for the dowry. Presumption under dowry death is defined under Section 113B Indian Evidence Act 1872. This section says that whenever there is a question of dowry death, if it is proven that woman has been subjected to cruelty or harassment soon before her death in relation to demand for of dowry, it will be assumed that the husband has caused the said dowry death. The presumption law. Section 113B Indian Evidence Act 1872 does not use the word shall but may, which mean that it is a presumption law. Whenever there is a use of may, it should be considered as a presumption law. It implies that when prosecution proves that it is a case of dowry death, it becomes important for the court to raise a presumption that it is the accused only who has caused the said dowry death. The legislature has made it a mandatory presumption of law. If it is proved that the victim was subjected to cruelty and harassment soon before the death in relation to demand for dowry, then the presumption under Section 113B Indian Evidence Act 1872 can be raised. Here, cruelty not only means physical harm but also mental torture. If the prosecution is unable to prove that the case was one of the dowry death, this prosecution presumption cannot be raised. Landmark cases in Hemchand versus State of Haryana. In this case, the parties were married on 24th May 1962. The bride returned to her parents' house after staying in her husband's house for 2 months. The husband has demanded for a television set and a fridge. To fulfill this demand, the bride's father has given 6,000 rupees to the wife and sent her back to her matrimonial house. This time, her husband demanded 25,000 rupees for purchasing a plot. Then the wife brought back 15,000 from her house and promised that her parents would pay the rest soon. After this incident, she was strangled to death in her husband's home. The court held that although the prosecution had proved that the case was one of the dowry deaths, they were not be able to prove that the husband had a direct relation with the victim's death. The accused was not charged under Section 302B, which charges for murder, but the Supreme Court raised the presumption of dowry death under Section 113B, and the accused was convicted under Section 304B IPC. In this case, it was proved that the death of the victim was unnatural, and thus the provisions of presumptions were raised. The court balanced it out by balancing the sentence awarded to the accused. Keshav Chandra Pandey versus State. In this case, the court held that presumption under Section 113B of the Indian Evidence Act will be raised only when the prosecution has proved beyond doubt that the death which has occurred in relation to dowry only, that is, it is indeed a case of dowry death. Best of luck for all, and thank you for listening. Please like, share, and subscribe and comment.